part of a series of activities that the Arts Project, which is funded by a very generous grant from the Rockefeller Foundation, put on in association with the Full Frame Documentary Film Festival. When Full Frame came to Durham, as it did every year, we put on a conference here, and we also ran a contest, and we're going to be announcing the winners of the contest today. We need to thank a number of people. First of all, obviously, the Rockefeller Foundation. Jennifer Jenkins, who's the main organizer, deserves much of the thanks for running all of this. Obviously, the entrance. We need to certainly also organize or thank Creative Commons, who actually had a moving image contest, which we shamelessly stole the design of this contest from entirely, and even many of the prizes, actually. Well, we didn't steal the physical prizes, but the idea of the prizes. We also, Laurie Racine, who we'll be talking about a little bit in a moment, was one of the key organizers. So thanks to all of them. I'm going to turn it over to Jennifer now.
This contest actually grew out of the Framed conference that we held last year, which brought together documentary filmmakers and musicians with academics and lawyers to discuss the ways that intellectual property law affects art, specifically how the rules set out by the intellectual property system shape or change artistic decisions and the framework in which artwork gets made. We believe that intellectual property is very important to artists. It allows them to control their works, sometimes allows them to get paid for their works, and provides the mechanisms that pay for the networks that distribute artistic works. But at the same time, we thought that there might be a neglected side to the question. Does intellectual property law actually constrain as well as help artists? So at the Frame Conference, we set out to analyze that question, particularly in the context of documentary filmmaking and music. You can find excerpts from the Frame Conference at the website that you see there. We knew that there were going to be some really interesting issues raised, but we were actually quite surprised by some of the things that we found out.
Yeah. Everyone has their favorite memories from the conference. Those of you who didn't see it, we actually have, as Jennifer mentioned, nice videos up. One of my favorites was Chris Hedges, a very distinguished documentary filmmaker who works with Mr. Pennebaker, was talking about the documentary film on Bob Dylan called Don't Look Back. And she shows a scene from the end of this movie where Dylan is riding in a car, actually with the documentary filmmaker. And she says, well, what's missing from the scene? The titles begin to roll. And everyone's going, well, what's missing from the scene? There were no music credits at all. This entire documentary, which was following Dylan around, all of the concerts, all of the songs, all of the things he was playing, jamming with other musicians, they hadn't got any credits for and hadn't sought clearance for any of the music that was played in the documentary. It was assumed this is a documentary about music. Of course we've got music in it. We don't need clearance for it. In fact, we didn't even need to mention that it was on there. It's a documentary about musicians. What did you think we'd be covering? And she said, now, of course, 20 years later, that would be totally different. And that was one of the things that the conference really highlighted, was a change in practices in the way that people made documentary films now and how much they had to pay, how much attention they had to pay to licensing.
One of my favorite memories from the conference were some stories that were perhaps more chilling about the ways that licensing practices affect whether documentaries, in particular important historical documentaries, are available at all. Many of you may have seen or heard of the documentary, the 6-part series, Eyes on the Prize, which is an important and some say the principal film account of the civil rights movement during the 50s and 60s in the US. At our conference, Orlando Bagwell, who worked on the film, described how Eyes on the Prize is actually no longer in circulation because of the prohibited costs of renewing expired licenses for things like newsreel footage and music. The producers of Eyes on the Prize currently have a grant to just research how much it would cost to actually renew the licenses, and some speculations that it would be in the neighborhood of $500,000. And so we have a case of sort of disappearing history, disappearing accounts of history, which I thought was very interesting.
So fascinating. I was actually planning on buying that DVD to show to my children and realized, well, you actually just can't buy it anymore, except on eBay, where it commands enormous prices.
And when you search it on Amazon, Eyes Wide Shut comes up, which is a very different...
You can watch Eyes Wide Shut, however. In legal terms, I mean, one of the things you'll see here is that the movies, which we were wanting artists to give their views, and so obviously if you're looking at it from a lawyer's point of view, there's some things that we noticed that they don't, and vice versa, I hope. That's the whole point of this contest. One of the things we did notice is an enormous difference, which we expected, but it was fascinating to find out about law on the books and law in action. Those of you who've done intellectual property, copyright, know that, would be thinking, but surely many of these snippets that are caught in documentaries, you catch a fragment of a TV show playing in the background of the character of the person who you're covering, or there's a song playing in the location where you're filming the documentary. Aren't these fair use, you'll be saying, to which my answer is, yes, actually they should be fair use. It wouldn't be a violation of copyright. But the question is not whether or not they are fair use if you could get to an appeals court or to the Supreme Court. The question is whether you'll be able to distribute your documentary without an errors and omissions insurance policy. And of course, the people who write the insurance policies, which you need in order to get distribution, have no incentive to take aggressive fair use positions. So one of the things we discovered is that the gatekeepers here are not, in fact, of course, the courts, but the lawyers who work for the insurance companies who decide whether or not this is an acceptable practice. And their tendency has to become more and more conservative. The theory is often, in many cases, you pay for everything. There are also interesting things. We won't go on because we know you want to get to the movies, but fascinating stories about music. Our own Anthony Kelly from Duke, a very distinguished composer and performer here, did a wonderful coverage, which you can see on our website, of a sort of little 10-minute story of how many composers have stolen from each other through history and how they did it, with playing examples as he went. It's really fascinating, well worth looking at. One thing I should mention, this contest is only one of a number of activities we're doing, obviously the conference. The other one to be coming out, we hope, sometime in the middle of this year, is actually what's pretentiously called a graphic novel, and it's actually a comic book, on the effects of IP on art. Jennifer, Keith Aoki, and I are working on a comic book depiction of the effects of IP on art, which we think is the kind of thing that might be kind of interesting on the web, and also might be the kind of thing that might get some circulation in film schools and music schools and so forth. So we're trying to reach across the divide. For some reason, these documentary filmmakers don't seem to want to read law review articles. I'm just not quite sure why that is, but we're exploring other formats.
So we posted 8 finalists, you can see, about a month ago on our website, and any of these finalists would make a great legitimate winner. And we also received a lot of entries that didn't even make it into the finalist group that we all thought were excellent. Since we posted these finalists, we've gotten extraordinary interest. We've had over 13,000 downloads, and that doesn't even count mirror sites and a BitTorrent that was set up. So it's really gotten a lot of buzz and interest from the online community.
Yeah, and the great thing about this is what follows is we had no role in picking the winners. I'll be telling you about the judges in just a moment. But we had no role in picking the winners, which initially I thought, well, that's sad. We set up a contest and we don't even get to pick who win. I'm now totally delighted. This is like blind grading numbers, which any faculty member will tell you is not for the protection of the students, but for the protection of the faculty. We had no choice in picking the winners, and they're so good that I'm very glad we didn't. So we can wash our hands of this and say that we're instead relying on the judgment of our excellent judges. Paul Jones, who's the head of iBiblio at UNC. iBiblio is perhaps the foremost digital library in the world. And Paul is sitting there in the center there, clutching his duck. Paul is also a distinguished published poet and just a fascinating person and a great friend of us here at Duke. Laurie Racine. Laurie is the president of Documentary Arts, which puts on the Full Frame Documentary Film Festival every year. A film frame which was previously called Double Take, the Double Take Film Festival, which is really the leading documentary film festival in the United States. And we also have Glenn Brown. Glenn is the executive director of Creative Commons. He was the one who came up with the original idea for the moving image contest. He's a very fine lawyer. And all of these movies, by the way, are under Creative Commons licenses, which is why they can be downloaded, put on BitTorrent, whatever, mirrored. They're free under the conditions that the authors actually set to be shared with all of you. So let us now turn to the key moment.
The exciting part. Can I have the envelopes, please? The
first envelope. We have 4 envelopes for 3 prizes. Obviously, our judges thought it would. This has given us a tie at 3rd place. So here is number 4.
All right. We don't have the great music that plays in the background of the Oscars, but you know, maybe perhaps you'd be willing to sing. All right. The first 3rd place winner is An Army One by One by Christopher Sims.
And that will be winning an iPod. This is, here we go. So,
before you get the wrong idea, that's not me, or anyone I know. All I know about this man is that in 1948, he became the first post-World War II draftee inducted into the U.S. Army. I found the silent film footage in the National Archives when I was conducting research for my own film, one about U.S. Army recruiters in the lead-up to the war in Iraq. In the spring of 2002, I got permission to be embedded with U.S. Army recruiters. I followed them throughout the North Carolina Piedmont as they looked for young men and women to volunteer to join the Army. Maybe it shouldn't be a surprise, but much of what I saw can also be seen in the silent footage from 50 years earlier. I saw sons kiss their mothers goodbye, though never with this number of takes, and the purposeful shuttling between venues and the paperwork, and as you'll see later on, the fingerprinting and the swearing-in ceremony, they are nearly identical to what happens nowadays. But there were also differences. I remember being in one recruit's living room, and no matter where I stood, there was paraphernalia from the movie Shrek in every shot. And you know what was playing on TV in one of the shots at the military entrance processing station in Raleigh? The show Saved by the Bell. It's bad enough that this is the last show the recruits would watch as civilians, but now I have to edit around it. Thanks to the internet, I learned that there was an episode of Beavis and Butthead where they go into an Army recruiting office. They try to sign up with the joke names of Major Woody and Private Parts. I wanted to use the footage, but you try and get MTV to write you back about a 10-year-old cartoon series. The U.S. Army has been in Iraq for more than a year now, and I'm still trying to figure out which footage I can use and which presents some potential legal liability. Watch the silent film footage from 1948 again. You won't see a single corporate logo or material that might have to be cleared. The uniforms and flags look more or less the same, but what goes on in the background has definitely changed.
There we go. One of the things that's great about watching all of these, and indeed watching all of the finalists, was that they brought up a lot of things that are very interesting. One thing that this brought up, this was, I have to confess, one of my own favorites, was that the changes here aren't just changes in licensing practices, they're changes in how much we are embedded in a sort of media-saturated environment, how much copyrighted content there is around us, so that if you look, there is, stuff playing, music playing, bits of movies, and also trademark. One other thing that was interesting is it was quite clear that a lot of the people who did entries, and this indicates the need for education here, believed that every trademark had to be cleared in a documentary. And you even have film students airbrushing out or blurring over every logo that appears, for example, on a hat. So if you imagine walking through a New York street scene and trying to not see a logo, I mean, you just have one big blur, right? And that, of course, is not true at all, right? I mean, that's
yes. I mean, these kinds of incidental appearances of trademarks are not incidents of trademark infringement at all.
Yeah.
In order to actually infringe the trademark rights and assign our logo, you would have to use the logo in a way that misrepresents or is likely to confuse the public about what product the trademark represents, which is certainly not the case where a trademark appears in the background of a movie. So the practice may be driven by erroneous legal advice or overly cautious filmmakers, but it's actually not illegal to have, a FedEx Express truck driving by in the background of your film. You don't have to airbrush that out.
Right. Although, who knows?
Although, who knows?
Okay, number 3.
Number 3. Number 3, also the winner of an iPod, is Stealing Home by Terry Tucker and Andrew Fazekas.
And Stealing Home, I'm glad to say, is also the winner of our People's Choice. Well, I'm hoping that they'll get the right one. Stealing Home is also the winner of the People's Choice Award, which is, we had as an additional thing, since all these people were downloading it, we thought we should also have not just our judges' views, but the views of people who were watching it. Which ones did they have? So we had a site where you could vote, and this is the winner of that prize. So they also win an additional $100 certificate for their role there, and I'm hoping we're just about to see it. There we go. Terry Tucker is a Duke Law grad.
You guys want to play some ball, all right?
Whoa, hey there, Timmy. What are you doing with that camera?
I'm making a documentary.
Oh, is that right? On what?
Joey Lavender. He's my favorite baseball player.
Timmy, did you know that some people might say you're stealing? I'll take that as a no. Well, Timmy, you're not the only one. Hi there. I'm John Johnson. If you're like Timmy here and plan on shooting a documentary, you better be careful. Violating intellectual property laws can put your movie and your piggy bank in serious danger. So be sure to follow these steps before you start filming. First, get a release agreement from everyone you capture on film, especially if they're famous, like Joey Lavender. Otherwise, they may sue you for commercial appropriation. Next, get permission to use any logos or trademarks that appear in your film, like the one for Coca-Cola here. Otherwise, they may sue you for trademark dilution. Finally, be sure to get permission to use any copyrighted material that might appear in your movie, like movie clips from past games. Otherwise, they may sue you for copyright infringement. So, Timmy, how does that sound?
I don't want to make a documentary.
Well, Timmy, you run along now. Well, there you have it. Avoiding intellectual property lawsuits when shooting a documentary is as easy as 1, 2, 3. I'm John Johnson, and this has been Stealing Home, how to get the rights to your documentary. So long.
Also bringing up some wonderful legal issues, including rights of publicity. And now, number 2.
Number 2. Number 2, Music for Our Grandchildren by Alec and Kuba Tarkowski. They win a digital movie camera. Interestingly, are from Poland, I believe.
Yes,
the
absolutely.
website wasn't how it was.
One of our foreign entries, and one of the few about music, actually.
Music is fun.
True. Sometimes it's funny and exciting, like when samplers came, when Grand Wizard Theodore did the first scratch, when Sean Fanning made Napster.
Well, sometimes it's not so funny. The Induce Act could soon make any culture-making device with the potential for copyright infringement illegal.
Recently, the court decided that NWA had no right to freely sample a 3-second riff from Get Off Your Ass and Jam by George Clinton and Funkadelic. The court said,
if you cannot pirate the whole sound recording, can you lift or sample something less? Our answer is in the negative.
We say, if the smallest bits crumble, the whole might tumble down as well.
And the Attorney General said,
I don't think we have a public domain attitude.
And little did he know that one day indeed we would have no culture whatsoever. How do I know this? I am Manfred the Great, transgalactic time traveler, granted the license to freely sample from Future's alternative by a freak accident. I will now bring you musics of the future. There is a future that's silent, and even the heartbeat is copyrighted. There is a future in which recording devices are extinct. Music is played, but never stays around for long. There is a future that unravels to a bland soundtrack of corporate pop. And there is a future surprisingly familiar, where bits of Elvis or Janis echo in futuristic compositions. Now is tomorrow's past. Remixers of the future await beautiful songs of today.
We've got the music of our ancestors to enjoy. What music will you leave for your grandchildren, 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 grandchildren.
And now the moment we have all been waiting for.
Thank you. All right. The grand prize winner of a nice movie editing suite is Powerful Pictures by Daniel Love.
My name is Dan Love, and I'm a 20-year-old student and filmmaker. Last April, I was confronted with a difficult moral dilemma. How could I reconcile the difference between my values of preserving intellectual property law with my desire to produce a powerful piece about the civil rights movement? A friend and I wanted to enter a contest held by the ACLU to produce a public service announcement commemorating the 50th anniversary of the Brown versus the Board of Education decision. We located many powerful civil rights photographs and songs on the internet, which we wove together to tell the story. Then we noticed the fine print. It said our entry wouldn't be accepted unless we had written permission from all our sources. As students, we couldn't afford to pay for the songs and photographs we had used. We weren't sure what to do. Luckily, I knew a civil rights photographer who allowed us to use his pictures. For without the chilling images of a dog attacking a young man or people being sprayed with fire hoses, how could we convey the violence, triumphs, and overall importance of the civil rights movement? We also used a few public domain photographs and applied to the Smithsonian Folkways recordings for the music rights. Even after we had done all that, we were still worried we hadn't followed intellectual property law in creating our art. In the end, we decided any oversights are fair use and submitted our PSA. Here it is.
No segregation, no segregation, no segregation over me, and before I'll be a slave, I'll be buried in my grave and go home to my Lord and be free and be no more dogs, no more dogs, no more dogs.
Thank you very much. Well, that's the end of our announcement. What I thought we could do is you can sit around, eat some more pizza, and we'd be delighted to just talk and have some sort of back and forth with anyone who's interested to talk about the subjects of the movies. I thought there were a couple of things that I was struck by in looking at these. The first was, I mean, these really are amazing. They're amazingly creative entries in here, including in the other finalists. If you haven't looked at them, I really encourage you to do that. But one of the things that was interesting is how little information there was, clearly, for the people who are making the movies for our contest to actually find out what the law was so that they were describing it. So that many of the entries were full of complete misstatements, which the people themselves had actually been obviously making documentary films under the effect of. The second thing, which is maybe cuts against some of the trends that we've been talking about, is that some of the tendencies that we were describing are driven by the fact that documentary films have now become big business. This was one of the things that was pointed out to us by the documentary filmmakers. Because of all of these sort of, a documentary about John Lennon, these sort of biographies that people show which have, famous people that are showing, constantly on cable TV, those apparently are actually money makers. The result of that is that there's actually money in this, and so you have an environment where the person who's doing, the documentary on the civil rights movement or the documentary on one of my favorites was a view of Wagner's Ring Cycle as seen from the stagehand's perspective, a documentary which is called Sing Faster, in which the documentary filmmaker accidentally captured a tiny fragment, about a 5-second fragment of The Simpsons in the background as a large lady is dying interminably upstairs. The stagehands are downstairs playing cards with The Simpsons in the background. And it was a great moment, sort of high and low culture, literally, physically transposed. Unfortunately, I guess it would be Fox, asked for, I think, $12,000 to clear that segment, that 5-second segment. And in the end, they had to airbrush it out. Which is what happens a lot of the time, and you probably don't realize it, replace it with some other movie. So that what you're actually seeing playing in the TV, you may notice A Wonderful Life seems to be playing a lot. Well, that was during if the soundtrack's off. That's because the part of A Wonderful Life, the movie A Wonderful Life, not the soundtrack, but the film itself, passed into the public domain, or some other public domain bit of film is put onto it. Also, the music that you hear may not be the music that was actually happening at the time. Chris Hedges told stories of her documentary, which was following, which band was it?
Depeche Mode. Depeche Mode 101.
The following Depeche Mode 101, and then they're playing a music box they just happened to have bought. But the music box was playing a trademarked song, a copyrighted song, which was?
Raindrops Keep Falling on My Head.
Raindrops Keep Falling on My Head. So instead, they had to get rid of that and substitute London Bridge is Falling Down. And then they have to get them to lip sync to it, like as if this is what they're watching. So there's this kind of pervasive re-engineering. You might say, well, you know, this isn't that important. I mean, it's sort of somewhat bizarre, and it seems like a waste, and doesn't seem like it's what copyright law is designed to do. But, you know, who cares whether it's London Bridge or Falling Down or Raindrops Keep Falling on My Head? Of course, I don't like the whole sort of re-engineering idea, but when you get to things like Eyes on the Prize, then it really does start to sound sad, because how do you tell the history of the civil rights movement without the music that went along with it? How do you not capture copyrighted images? And if you have to clear that whole bundle again and again, these rights permissions expire, that stuff is simply not going to be around. So those are among the sort of negative themes that we took away from the competition. One of the positive themes, though, and maybe this contest is an example of it, is one of the main gatekeepers, as we said, is errors and omissions insurance. And to the extent that people can distribute via the internet and can take on themselves and the websites where they distribute the risk themselves, then that's not so much of, there's not so much of a gatekeeping function. Of course, that keeps you off cable TV, and you may not even be able to display at film festivals, but it is an alternative channel of distribution, and in that sense, things are better. So any questions for me or for Jennifer about the project or about the winners or the contest? Yeah, Caleb.
Copyrights that you couldn't consider?
Not that we could, well, certainly none that we were aware of. We asked everybody to clear copyright, and here's what our judge, Paul Jones, big hand for Paul Jones, one of our judges. We had segments where the people were going on about how terrible it was and how they had to clear every copyrighted segment, while it appeared to us that somewhere playing in the background they hadn't even noticed was another piece of copyrighted music, which they hadn't, they probably hadn't cleared. So that did happen. But it wasn't as big of a feature as we had imagined. What we were, we were concerned that some people would say, oh, well, great, we'll treat this as a piece of sort of daring agitprop art, and we'll put in, we'll take, an entire Madonna, music video and sort of submit it as our entry. We didn't get anything like that. Any other questions? Kate.
Do you intend to do anything with these besides the very important thing of having these accessible? Like, is there anything else that's part of the project that is the next step?
Well, I'll speak to part of it and then turn it over to Jennifer. What we're trying to do is put together a whole sort of package of materials, audiovisual materials, text materials, this sort of comic book that we're talking about, that people could use. So the idea is to, for example, have the website set up so that someone who's teaching a class in a film school and wants to raise these issues, and also maybe to get some education about what the issues are, could go to it, could play these, could see some examples of it. Garrett Levin, who's sitting at the back there, one of our many superstars here at Duke, did a fabulous job of editing down long-winded law professors and rather more pithy documentarians and musicians into tight little 7- and 8-minute videos from the conference. They're really fascinating. I mean, they actually are really, really good. He actually makes us sound much, much more interesting than we actually were. And so already we've had reports that a number of people are using those in their classes. So we're trying to sort of put that together and sort of publicize it and make it available. One of the things that happened is in this, we got blogged early on when we put this contest, and our hits counter, which was sort of clicking up, suddenly started going brrr, like this. We were having literally thousands of people in a day download the movies. And a number of other people seem to be taking the movies and using them themselves, which is part of the idea, since we make them available under Creative Commons licenses. Jennifer, you want to add some stuff to that?
Yeah, I'll pick up on the Creative Commons licenses. Both the excerpts that Garrett put together from our conference and the contest entries are all licensed under Creative Commons licenses, various different licenses, which means that they will have a life after what we're doing with them now, because anyone can use them with attribution, depending on what the licenses say, without worrying about copyright, because the licenses tell you what the authors will allow you to do. And so, people want to show them in their classes, use them for other purposes. Kem Rogerson from Public Policy, indicated that he wants to use the contest finalists in his class to make a lot of points. And so they will have lives, educationally or otherwise, beyond what we're doing with them now.
we're also hoping to take it back to when Full Frame returns. We hope to have both these movies and the sort of textual materials available to distribute to the participants. So it's kind of a report a year later. You know, we had the conference, we followed it up. This is what the artists are thinking, and sort of turn it back to them and see what they can remake with it.
Yeah. I just wonder, what's the relationship in the project between simply informing people of the law and moving in the direction of changing the law? And to the extent that there's some of the second, I'd just love to hear either one of you reflect on how this project is distinct from traditional legal activism in the sense that instead of going to courts, you're contributing to a kind of viral constituency for a different view of the law and its import in these areas.
Well, it's a very good question. I mean, one of the things that, one of the sort of the many humbling things about this, I mean, including how many incredibly talented and creative people are out there who will, you know, spend vast amounts of time making things for, you know, the promise of an iPod. One of the humbling things was that, you know, to be honest, I had read a lot about this. I had read, I think, all of the published accounts. I had talked to a lot of documentarians, and I thought that I had a pretty good handle on what was going on. And in terms of the law reform part, one of the things I discovered in the course of this was that actually there were huge, huge swathes of what was going on that I didn't know. For example, and this goes to your law reform question, there's a section on there where I'm talking to John Sloss, who's one of the main lawyers who deals from the documentary filmmaker side with both the distribution companies and the E&O, the errors and omissions people, the insurance people. And so we'd had a little sort of, you know, faux Socratic dialogue where I was saying, you know, I learned in law school that in a perfect market there will be a distribution of risk preferences among insurance companies. And there will be insurance companies who are wishing to take risks, and there will be conservative ones, and the rates will vary. And he goes, well, first of all, that's not true, because since September 11th, there's been an incredible consolidation in the insurance industry. So there are very few firms. He goes, and besides, all E&O companies get their legal advice from a single guy, from one person. He goes, who's, you know, as he described him, 108. And he's a great guy. He lives in Los Angeles. You know, he actually names him. He's like, you know, and, you know, he sits there. He's sort of a wise man. They come to him, is it fair use? He goes, no, it's not fair use. Yep, it's fair use. No, it's not fair use. Yep, it's fair use. So the idea that there would be a distribution of risk preferences, kind of, you know, you've got a single, you know, there is in fact, if there were a single person who decides fair use issues for the industry, well, effectively there is such a person. So one of the things that I think that will come out of this in terms of law reform is that I do think that there's a danger whenever legal scholars do this, of kind of, you study an area and you think, okay, well, I know what the artists want, or I know what this group wants, and I know what the problems are. And by doing this kind of rather more lengthy investigation, I think we found out a lot, so that I now have a much better sense of what the failure points are. You know, changes to the law of fair use in the abstract might produce little effect on this. You'd have to have some combination of that with education, with some attempt to say, how do we want to do this? PBS, for example, has a special license to basically take music on a flat fee. And as a result, PBS documentaries are in a very privileged position, and so you have a lot of PBS documentaries with great music. The flip side of that is, of course, that stuff then may not be available because that license may apply only to PBS and only to showing on PBS. You know, do we need to think about proposals for sort of statutory compulsory licenses for this kind of thing, where this is a point that David Lang has made? It may be that we need to separate the claim of, I get to use this whether you say no or not, with the question of, but maybe I have to pay you if there is in fact an income stream to be designed from it. And our own dear colleague Jerry Reichman has written on the issue of liability rules and how that might do it. So I think it does suggest a whole series of things. But the other thing is, for the first time, I think, in at least my understanding of intellectual property law, you have this engaged audience that is beginning to say, this stuff is now impacting our creative practices directly, and we want to get involved and say, this actually isn't what we need. You're not giving us the stuff that we need. And that's where I see the main effect of this. I don't know if you have comments to add to that?
I mean, and also one of the unique things about our approach that I think worked really well is getting, you know, beyond the text, beyond arguing, and using things like, you know, the internet, visual images, the graphic novel that we're making, and, you know, packaging things in a way that really resonates with the artistic community and allows them to engage more. Yeah. And I mean, the conversation, bringing just lawyers, whoops. and bashing around microphones. Bringing lawyers and artists together at our conference was really incredible, and we got all sorts of things that either one of the populations alone probably wouldn't have been able to produce. So.
One of the more memorable confrontations at the conference was we had one of the members of the music band, the appropriationist band Negative Land, who had been sued early on when they released their parody, The Letter U and the Numeral 2, which was a large album. It was, in fact, a vinyl album which had U2 on the front and a picture of the U2 spy plane. Then had a parodic version of U2's I Still Haven't Found What I'm Looking For, interspersed with some obscene outtakes from Casey Kasen's, lamenting the fact that he was being forced to play this song by U2. He says, it's just a bunch of letters and numerals, and these guys are from England. Okay. These guys are from England, and who gives a damn? And various other things, which I won't repeat. In any event, U2, Negative Land, who were distributing this, were sued and had to take the record off the market. And we had a memorable confrontation between the member from the band and the person who had actually bought the album, which was the key album in the lawsuit. He said, and I believe the guy who bought the album was the lawyer for such and such a band. But yes, I know. I was trying to be diplomatic, Paul. The lawyer for REM. He's like, is blank blank in the audience? I am. Well, and you know, the confrontation proceeded. But in the end, we were able to achieve a reconciliation. They signed each other's books, said that they would assign each other's writings in their own respective classes, and were reconciled. So we're kind of hoping it will bring happiness to the whole area.
And came to a mutual understanding of each other's point of view, like, really,
yes,
which
I think,
yes. Some publicly, some privately. But
yes,
it was. Anyway.
So, any other questions?
So did the conference conclude that IP's helping or hurting art? Was there any clear way, one way or the other?
I think, I think the first thing I'd say is I actually think it was very interesting. I thought it was clear that the people focused mainly on the way that IP was hurting, and that they probably didn't adequately focus on the way that IP was helping. The kinds of creative control it gave. Now, there I think we could have our own fascinating exploration. We may do more of this in the future. One of the things is, what does giving different kinds of intellectual property rights to an artist who then has to deal with a distributor or record label, how much power does that actually give them, and how much control, and how are the contracts written? And if you were going to deal with that, would you change the intellectual property law, which probably has relatively little to do with it, or would you try and develop alternative channels for distributions, different model contracts, and so forth? So I think that side was rather neglected, I think, or at least underemphasized there. I would say there was a consensus among the filmmakers that they were kind of muddling along, and a lot of them said, hey, I like getting paid when it's my stuff being used. But it wasn't clear that after all of these people that I paid for yours and you'd pay for mine, and a lot of lawyers that got paid, at the end of the day, whether this was actually doing any good. And I looked at it, I have to say, I won't put words in other people's mouths, and thought the legal system is not functioning the way it's supposed to function here, at least on the private level. And so I think we need to see a change of practices and maybe some better understandings and maybe some legislative rules, because you can't make documentaries without capturing copyrighted culture. That's just the way it is. And if you treat that as if it were just the same as me making a movie, a feature film, and taking a snippet out of another feature film, you're really kind of missing the point. So I think that was the consensus I came to. And it was interesting, a lot of the filmmakers and lawyers seemed to agree on this. And although they seemed to say, it's like, this is just the way things are, nothing can be done. And it was the younger filmmakers, I thought, who were rather more not willing to accept that. It's like, they didn't want to accept that the change was permanent. Okay, thanks very much.
Thanks for coming. Thanks, Paul, for